Hello.
Hi, I'm waiting for everyone to get logged on and we'll go ahead and start. Let's start by identifying some people. I have a Benjamin Milbrath,
That's
which
me.
is with the Long Bridge Land Holding Company. I see a Robert Beechler, which I have on my certificate of service as being with the Idaho Transportation Department.
That's correct.
John Richards, who's the attorney for the Idaho Department of Lands.
Correct.
And then I have a Scott Hansen. Can you identify yourself and who you're with?
Yeah, with Lane Co Marine. And Lance Lane is here as well.
Are you an objector in these proceedings? Or are you with the applicant?
We're with the applicant.
Okay. And who did you say you were with?
Lane Co Marine.
No, who's with you on your Zoom call?
Oh, Lance Lane.
Lance Lane. And I apologize for those of you that are outside of Boise, you do not know that we're suffering an extreme inversion right now. And so I am not sick. I am just a victim of the air quality that we are experiencing here right now. And then I have a Jay Wilson.
Yeah, hi, this is Jerry Wilson with the Idaho Transportation Department.
Okay, thank you, Mr. Wilson. Jerry Wilson with ITD. Okay, anybody on this call anticipating anybody else joining us here today?
No.
All right, hearing none, then let's call this matter to order. This is a matter before the Idaho Department of Lands in the matter of Marina Expansion, Long Bridge Land Holding Company, LLC. Benjamin Milbrath as applicant. Agency case number PH-2024-NAV-20-003. Office of Administrative Hearings case number 24-320-10. I am the assigned hearing officer, Leslie Hayes. Prior to calling this matter to order, I identified everybody on this call and who they're with. We're here today to set this matter for an administrative proceeding. My understanding is this is going to be a public hearing held after 4 or 5 in Sandpoint, Idaho. I will probably take lands up on it couldn't be held at 4 o'clock. Because that expands our options for hearing locations in Sandpoint. And it also lessens any time restrictions that I need to put on the hearing. I usually want everybody out the door by about 8 o'clock. Just for ease of identifying a suitable location for dinner for those of us that travel from out of town for these proceedings. So with that, we have a hearing deadline of January 22nd, I see. As you can imagine, I'm pretty booked up between now and the end of the year. Plus, we need to be able to give lands the 14 days notice to advertise the hearing. So that puts us into January. So I will turn over to you, Mr. Milbrath. Do you have a preference in January as to when we hold this hearing before the 22nd? So that puts us into the 4th week of January.
So it's my understanding as applicant that it has to be before January 22nd, but do I have the option of doing it later, as I will actually be out of the country? The earliest time I'm back in country is January 27th, 28th. Then I have February 14th, and then I have the first 2 weeks of April. But those, for me to be present, those are the only dates I'm able to be present, and I don't mind it being pushed out a little bit time-wise, because we're not planning on doing any work this winter or summer if we're approved.
So my understanding, and I'll let Mr. Richards jump in if he has objection to this, is that the applicant does have the ability to waive those statutory deadlines.
Yeah, and that's accurate. Those deadlines are there to make sure that the application
the applicant's application is processed efficiently, so they do have the ability to voluntarily waive that deadline if that's what Mr. Milbrath would like to do. So we could bump it out farther. We would just need that reflected in the record somewhere that they voluntarily waived the 30-day deadline, or that, sorry, not the 30-day deadline, but that hearing deadline.
Yeah, I will probably incorporate it in my scheduling order, but I will probably also would incorporate it in any not final order, recommended order that issues from our office as well. Okay, so did I hear you correctly that the only dates you have available are September or January 27th, 28th, and February 14th?
Or the first 2 weeks of April. I'm actually available till December 27th, but it sounds like your calendar is full and that's kind of pushing it for everybody as well. So, but yes, January 27th, 28th, February 14th, and then first 2 weeks of April.
December 27th makes it tight for the 14 days notice, but I could make that work. I'm up there at that point already. Anyway, we'll be up in Sandpoint the 23rd through the 29th-ish. Similarly, January 27th and 28th are free on my calendar. And February 14th, I was intending to be up there that weekend as well for personal reasons. So February 14th is fine by me. 27th and 28th are fine by me on my calendar. And then the first 2 weeks in April, so the 1st through the 11th.
April. Yes, the 31st through the 11th.
Wide open on my calendar. Except for I have an in Boise engagement on April 6th, but that's a Sunday, so that could be worked around.
Yeah, I think February, either the January dates or the February dates would be preferred, but also amenable to other people's schedules.
I'm comfortable with the 27th or 28th. Mr. Richards, those dates work for you?
Yeah, either the 27th or 28th will work for me, and then that'll save me from having to explain to my wife why I'm in Coeur d'Alene on Valentine's Day. But I could make the 14th work as well if needed.
All right, so let's do.
Well, does the Idaho Transportation Department, we can put some input on these dates too?
Yeah, absolutely.
Just because it's the holiday weekend, I was already planning on being off that week. It's probably not a good time for other interested parties to attend.
What
We're talking
holiday?
December, right? We're talking December, or are we back?
No,
We're talking January.
Oh,
We're
okay, January. Okay, January is fine, that far out.
Yeah, so January 27th or 28th. Any objection to those dates from ITD?
27th works best.
Okay, January 27th. It will be. And then, Mr. Richards, this is the first case you and I have done together. I usually like to reserve the morning of the 28th. In case an on-site inspection will benefit all parties. I've read the record that I've received so far and being familiar with the exact intersection that ITD has identified as their concern. I believe that an on-site inspection would be of benefit so that we can get into the record what it is, the physical location of these, because I can't rely on my own personal knowledge. That's not considered evidence. But we can determine that closer to the hearing at the pre-hearing conference. So that'll give us time on the 28th to potentially do an on-site inspection. So just make sure everybody's travel plans account for that. So with that, let's see, I will go 2 weeks out to January 13th for pre-hearing disclosures. Does that work for everybody?
Yep.
Yep.
That works on my end.
Okay, and so that will be witness list, exhibit lists, and pre-hearing statements, if any. In these proceedings, Mr. Milbrath, as you might remember from the last application, which I will note for ITD and Mr. Richards was wholly different than this application. That's not always the case with duplicate applicants. You can rely on the face of your application as your pre-hearing statement. You don't, and same with you, Mr. Beechler. You can rely on your objection as your pre-hearing statement. I don't need you to reiterate those things for purposes of the record, but if you have additional information that you would like to add, you're welcome to do that. And then let's hold our pre-hearing conference on the 21st of January. Does that work for everybody?
That works for me.
I'll be in a foreign country on a boat, so is it something that's done by Zoom, I assume? I can try to figure that out.
It's done by Zoom, where you can send a representative. The purpose of the pre-hearing conference is to make sure that I have everything that the parties want me to have prior to the hearing, so all exhibits, knowledge of witnesses, if there's any sort of logistical hiccups that we've run into, such as we now have 300 public comments in the record, and we anticipate the size of the hearing expanding beyond what we think right now it looks like. So anybody that can speak on your behalf if you don't have sufficient service for that purpose, or if you just want to confirm that you have no intent to attend the pre-hearing conference, we can do it without you. Nothing of substance will be discussed in those proceedings, just procedural issues.
Okay, so I understand, since this is new to me, not having gone through this process before, we had a pre-hearing notice where people had people filed if they had an objection, etc. Do we have another notice period, and then who at that point can speak, and what can they speak on? It was my understanding that we're dealing with the concerns of the Idaho Department of Transportation. Are we now opening it up again to anybody that has a concern, or how does that work, or what do we limit it to?
Yes, so the Idaho Department of Lands will advertise in the local paper, which is the Bonner County Bee, notice of the proceedings. It will be open to the public. The public can come and speak. So public members may come and speak on the size of the project, how busy the lake is, environmental concerns that they may have, and whether or not that's admissible as evidence is a different question versus whether they can actually speak to their concerns or support of the.
Then what was the purpose then of the previous notice period that we gave to everyone?
The prior notice, I believe, only goes to neighbors that may have objection about interference within their littoral rights. But I'll turn it over to Mr. Richards to further explain.
Because I also thought it was published in the paper, so I'm just wondering why we go through that twice.
So there's two processes. There's the objection process, the initial one that you're talking about that we put out to see if anyone objects and calls for a public hearing. If a public hearing is called, then it opens it up for that additional comment period for the public to have input. The purpose of the public hearing generally, once it's called, is to allow one, the objector, but also all members of the public to continue to provide input to the departments to inform our decision. So the first period is just to see if anyone is going to object and call for a public hearing. And if it's called for, then it extends that period out to allow additional time for the public and the objector to submit information to the department.
So what objection, I mean, does it essentially open up the entire process again, so anybody can file an objection and can be heard, or is it just letting people speak their mind and it doesn't matter because they weren't an initial objector, or how does that work?
So they can still speak their mind. So ITD is the only one that is an official objector because they filed within the period. So they have that objector status. Everyone else can submit public comment, and that can be considered by the Idaho Department of Lands in their decision. It submits information before the department that can be considered as part of the record, if admitted, and can be used to inform our final decision. And they can comment on any aspect of the application.
Okay, then if we have to rebut any of that, we would only have the 14 days basically from the end of that period of time to address that. Is that correct?
Not necessarily. So what I do is if there is significant public comment that is raising new, especially new information that you hadn't previously heard or new concerns, I will leave the comment or the record open for a period of time. We usually discuss that at the hearing to give you an opportunity to respond to those comments. So if you're hearing something for the first time at the hearing that's a concern of the public that may inform my recommended order or the final order of the department on the application, you will have an opportunity to respond to that, usually in writing 7 to 14 days after the close of the hearing. And then that's when we close the evidence, which starts the timeline for purposes of my order. And then the department's order.
Do we have the ability to post the notice further out basically or earlier? I mean, I can deal with any comments that come up during the meeting itself. But can we post that instead of, exactly 14 days before? Can we publish it a month before or 6 weeks before? So we have the ability, if we do get written comments, we've got more than just the 2 weeks to, obviously I'd like to reply to those sorts of things during the meeting. It's going to be most effective. So is it statutorily that the meeting notice has to go out, or could we send it out January 1st per se?
Mr. Richards?
Yeah, I'm happy to answer that. So the 2 weeks is a minimum. So we have to give a minimum of 2 weeks notice so that we can go out longer if we want to. We can post that notice earlier, but it has to be a minimum of 2 weeks. So I'd have to speak with our area office, but I'd imagine that we should be able to get that posted sooner than 2 weeks before the scheduled hearing.
Does it give them the same amount of time, or if we posted earlier, does it open it up for 6 weeks if we had posted a month earlier?
Well, yeah, it's once the hearing's set, the public comment, I mean, they can still submit comment without we'll post it on our website as well. But they can submit comment all the way up through the comment deadline, which usually, as Ms. Hayes mentioned, extends past the hearing date. So it'll still be open for the same amount of time. It's just whether we get the notice posted earlier or not.
So if we posted earlier, there's a longer public comment period.
Well, technically, the comment period would still be open now, even without us posting the notice. They could submit comments before we post our notice, as long as a hearing's been called and a hearing's been set, which once we get a scheduling order, we'll have a hearing date. And so they can still submit comments even before we post the notice. The notice is just to get the information out there to let them know that it's open and reach a wider audience. But someone who is informed on this could submit it earlier
Anytime.
if they were informed on the process.
Okay, I understand how it works. We can just stick with the normal procedure. I just wanted to understand how that works. So we don't need to do anything out of the ordinary.
Okay. Well, I will identify a location. My initial thought is I am going to attempt to utilize the hearing space at the library, which I think closes at 8, so they meet us out by 7:45, which is why the 4 o'clock start time is a benefit to us. We may have to pivot and change the hearing location if we think that a large amount of the public intends to attend the hearing. I can tell you that's not always something that can be forecast. I did a hearing in Spirit Lake last summer where we had a small classroom at the high school reserved, and we ended up having to move to the cafeteria at the last minute. So we like to give ourselves option because it's not always anticipated how these things are gonna play out. But I will try for the library at 4 o'clock on the 27th, as a hearing location. We'll do pre-hearing disclosures on the 13th. Pre-hearing conference tentatively for 2 o'clock on the 21st. And then Mr. Milbrath, if you don't have anybody that can speak on your behalf and you don't think you'll have sufficient signal to attend that hearing and you desire to do so, when are you gonna be off your boat?
I'll be back on land January 26th. January 26th.
What about the week of the 13th? Like if we did it on the 17th, would that work for you?
It won't make any difference. I'll be,
Okay,
I mean, I should have Wi-Fi. I should be fine. I haven't hired a land use attorney yet for this. And I don't know if I will. If I do, the attorney can appear on my behalf. So I can work through that, and Lance can always appear on my behalf. So I've got a couple other questions, but I can wait till you open up for questions at the end, because like I said, I'm new to this.
we're right there, Mr. Milbrath, so go ahead.
So I'm dealing with the concerns of Idaho Department of Transportation, which we want to make sure we fully consider. If there are statements, from the letter that Robert sent, one of their concerns was trailers and boats with trailers and things turning into the marina. We don't have a public launch and we don't have trailer parking. So that's, to me, it's not a valid concern because there won't be any trailer traffic associated with our marina. So how do we get certain things like that communicated to all the parties so we're addressing concerns that may not be valid or fully informed?
So that would be the purpose of your pre-hearing statement and any evidence that you provide at the hearing or during the on-site inspection. But you are free to call Mr. Beechler and have conversations with him prior to the hearing, because ITD may well find that their concerns are resolved based on your conversations and may withdraw their objection like that. That is a possibility that is open. You're always welcome to talk to anybody on this call outside of my presence.
Okay, that's what I was hoping to do, to hopefully address all those concerns, because I think they are addressable. But I didn't know if that was A, allowed, or B, well, I didn't know if it was allowed given the very formal structure of this process.
Yep, the only formalities in this process are when you're dealing with anything in front of me. Everything else is, you're welcome to just pick up the phone and reach out and make a phone call and ask the questions that you have, talk with ITD, talk with Lance. But whenever you're in front of me, I can only accept evidence that's admitted into the record. I can't accept just your statements that there will be an impact because you don't have a launch.
Nope, that's fair.
That can't be considered evidence at this point in time.
Yep, nope, that's fine.
Any other questions, Mr. Milbrath?
My only other question would be is if we addressed all of ITD's concerns, and if they withdrew their objection, then do we still have a hearing, or are we done at that point, or how does that work?
I will turn it over to Mr. Richards to answer that question.
I think at that point, because the hearing's been called and public notice has gone out, that likely the hearing would still take place in the event that any of the public want to submit comment, just because we've sent out the notice. I think there's probably some discretion we can on the department side, and we may be able to make a call if we haven't received any public comments, but typically we once the hearing's posted, we a lot of time we'll go forward with it.
So we would have January 13th, if that is when it's going to be posted. We'd have till January 13th to essentially resolve it if possible. Does that make sense?
It depends, and so, as I said, the notice could be posted earlier. That's usually handled by the area staff. A lot of times they will post it sooner or longer than 2 weeks. That's just the minimum that we have to post.
Okay,
So that it could get posted sooner than that.
okay, so but it was done before it was posted. Let's say we figured it out next week or the week after and it wasn't posted. Then does it get withdrawn or we still go through the time and expense of the hearing?
I think we'd have to look at still a discretionary decision, I believe, at that point on the department side. But I can tell you that it would be more likely that it would be withdrawn or that we would cancel the hearing if it hasn't been publicly noticed yet.
Okay, super.
All right, and Mr. Milbrath, I will tell you that even if we do go to hearing and ITD's concerns are resolved, I've seen hearings where lands had concerns and didn't recommend approval of the application. And lands comes to the hearing and says, all our concerns have been resolved by further evidence received by the applicant. We have no objection to this. We have 1 or 2 public comments and we still proceed with the hearing. So,
Okay, we'll see what happens.
how it plays out is how it plays out. So,
Yep.
Do you have any other questions?
I don't know if this has been very helpful.
Okay, Mr. Richards, anything else from you here today?
Nothing from my end, thank you.
And then Mr. Beechler, anything else from ITD?
No, thank you.
Okay, well, I will issue my scheduling order with all of these details here outlined for folks, and I will see you all except for Mr. Milbrath if you can't be there on the 21st of January.
And
All
Madam
right.
Hearing Officer.
Thanks so
um,
much.
I know that you had mentioned this before, but I'll just note one more time, if you could include in that scheduling order that the applicant waived their the deadline for the public hearing, that'd be appreciated.
Yep. Do you want me to send an email with that? Would that be helpful or not?
No, if it's in the scheduling order, it should be fine.
Okay,
Okay, thank you, Mr. Richards. Thank you, Mr. Beechler, Mr. Milbrath, and everybody else on this call. We will be in recess.
all right, thanks so
Thank you.
much.
You.